Welcome to the Thursday, November 19th, 2020 meeting of the Radnor Township Zoning Hearing Board. We'll begin with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Okay, we'll jump right into the agenda. First item is appeal number 2099. The applicant, Patricia McKenna, property located at 333 Chamonix Road, requests an extension of time for the obtaining of a permit under section 280-144 of the zoning code until April 1st, 2021. Is Mr. Keneally, is this one of yours?
It is.
Good evening.
And I see Steve McKenna, who's the spouse of the applicant, is on as well.
Good evening.
Good evening. First of all, is that appeal number right? 2099?
2999, right? Kevin, I think that's correct, isn't it?
2999. Okay.
I believe it is
All
correct.
right.
Yes.
Okay.
Yeah, I'm looking at
okay.
it now. 2999. That's correct.
Okay. Thanks. What brings the applicant here this evening?
This was an appeal that was granted. It was a small addition to the side, basically just squared off the house. Very small violation into the side yard setback. I believe it was maybe 20 square feet or something of that nature. Only extended for a couple feet. Actually, I do have the ability to put an aerial on if you wanted to see it. There's really nothing around it. It's pretty isolated property. What happened was that the applicant never commenced with the addition. There's a lot of things going on there. The applicant's husband was in the process of retiring. Now the situation has become such that they really need to create this lower room space. The applicant is somewhat disabled, and we're trying to get this done as quickly as possible now. It's really a master bedroom and master bath in the lower level, so everything will be on one level. So it's a pretty minor addition. Matter of fact, the board at that time said it was de minimis.
Okay, so but the passage of time was at least volitional from the aspect of the applicants for some period of time, but now there's the need to move forward.
That's correct, John.
Okay. Do any members of the board have any questions on this matter? Jamie?
Forgive me, it's a bookkeeping. It's by no way an opinion, and I wasn't there at that vote. My only question is in understanding, based on the order, and the relief would have run out 6 months from November 20th, 2017. Do we have the right to vote on an extension on relief that has expired? And maybe I'm just asking for myself. I'm not trying to put an opinion out that I would vote no in any way. I'm just asking, is there other routes that don't require this family to go through zoning again? But or I guess my real question is, has the relief run out? And do we have the right to vote on that?
I would welcome the thoughts of the solicitor on this, but usually our orders are rather explicit in that I believe at the bottom of each order there is the statement that the failure to obtain a permit within the specified period of time will render the relief null and void. Gus, do you have any thoughts on that?
No, that's correct. I mean, it's pretty clear on every single order we issue.
I agree.
Yeah, so I go ahead there.
Yeah, it's on this order, but of course the board in its discretion can grant extensions as well, which it frequently does.
Sure, it is frequently done, but it is more frequently done contemporaneously with the expiration of that 6-month period. And as Jamie points out, the time has one could argue that the time has run. Jamie, is that we have flexibility to grant extensions of that time period. I am unfamiliar on my time on the board with having granted one so far beyond the expiration of the original relief. But really, it is a matter that the board does have discretion. This might be the outside contours of its discretion, particularly, and I don't know if Gus, Kevin, I don't know if we have any public comment on this request, because sometimes passage of time can also mean changed circumstances in many respects, not simply the applicant's change in circumstance, but other people's view of the world, new neighbors, all sorts of things could change given the passage of time.
Sure.
So,
Mr. Chairman, we unfortunately don't have any comments for this, or fortunately, depending on how you want to look at it. As an extension, we do not advertise, we do not post the property. So the concerns that you've raised regarding new neighbors and things like that, they would not have had that opportunity to weigh in on, because we do not post the property and is not advertised as such. Routinely, these just come in front of the board as a matter of the board's discretion.
All right. Is there any dispute or any objection from the members of the board to the grant of this extension?
Yeah, John, it's Rich Weitzman. I would oppose it.
Hey,
my concern would be to set precedent that we're extending. As you said, it's usually done contemporaneously or more contemporaneously, and that would be my concern, is that we're setting some sort of precedent for something that expired 2.5 years ago.
So is there a workaround? Can I ask? And I'm just trying to be creative, and so that we wouldn't put this family under the financial burden of going through zoning again, based on the fact that it sounds like they didn't move forward on the paperwork because of financial constraints. Are there other routes to bring back the relief that doesn't require them to go through zoning altogether if we voted no?
This is really it. The request for the extension and the asking the board to exercise its discretion is really the only workaround.
Okay.
I mean, I don't know if it helps. I can, if Ian wants to let me share screen, I have pulled up here some of the exhibits that were previously presented.
Yeah, I don't know that it's necessary to relitigate the grant of the exception or the relief. I mean, I think, we're gonna take as a given the fact that it was appropriate to grant the relief when it was granted. Now is simply the question of whether some extended period of time after the expiration of the relief, whether we can, in essence, extend it that far beyond the date.
Well, this isn't exactly a project, that has a major significance on the township. It was a de minimis exception to begin with, and why do we need to waste people's time to do this again? No harm, no foul. Let's not be silly about it.
Yeah. My inclination is to proceed as George has suggested, and to grant the exception. Rich, I understand what you're saying. On these facts, I think we can distinguish future cases from the instant case. And I would be comfortable granting the relief, granting the extension. So I'm not sure if that requires a motion or simply the decision. Mr. Solicitor.
I mean, obviously, to put it, I would put it in a motion just to make sure we formalize this. And if you don't mind, with this particular extension, would you like me to do an opinion to show the uniqueness of the circumstances?
I think to let's yes, we can talk about that after the motion is made, and you know, I'm going to start a new precedent. I'm going to be allowed to make motions now too, so we can keep things moving. So I would move that the board grant the requested extension for the relief in appeal number 2999. Is there a second?
I'll second.
Okay, board discussion, and as the solicitor has indicated, I think it would be wise to make clear in a brief order the fact that this situation is unique, and that the basis of the grant of the relief in the original case was that of a de minimis variance, as opposed to something that constituted a much larger request for relief under the code. So is there any other discussion from the board? Okay, hearing none, I'm going to call the vote, and I'll do it by roll. Oh, sorry, Jamie.
Real quick, just a question for the attorney. Do we know if there was turnover of the neighbors since, because they weren't served notice, so they wouldn't know to come tonight and say anything if they were upset by it?
Yeah, I'm not really certain. I know the nearest neighbor is several hundred feet away.
Okay. Okay.
So.
Okay, thank you.
Okay, I'll call the vote on the motion to grant the extension. Jamie?
I'll grant the extension.
George?
We'll grant the extension.
Rich?
I'm going to say no, but I am glad with the distinction to be made in an opinion.
Okay, and I also approve the grant of the extension. So the prior relief is extended until April 1st, 2021, and a brief order will follow.
Thank you.
Okay, thank you very much.
I'm going to see you a little bit later.
Okay. All right, we move on to the next agenda item, which is appeal number 3080. The applicant, Garrett Hill Ale House, property located at 157 through 159 Garrett Avenue and zoned C1 commercial. The applicant seeks to remove condition number 14D imposed upon the property as part of appeal 2575 regarding windows being kept closed while the restaurant was open for business. The applicant received temporary relief from this condition as part of appeal number 3000, which is set to expire on November 21st, 2020. I would point out that participating in this hearing, Ms. Pilling, I see you on the Zoom. Good evening. Before we begin, are you looking to have party status in this matter as an opposing party, or are you simply seeking to participate via video this evening?
I'm seeking to participate. I was one of the originators of the Concerned Neighbors of Garrett Hill in 2000 to 2003 that resulted in the agreement that was made between the then owners of what had been called the Brick Bar, had then been renamed J.B. Garrett. And because I don't believe any of you who are currently on the board were on the board 17 years ago. And
yes, but some of us were on the board when the application that's in question now
I know that
was heard 3 years ago.
Right, but I would very much appreciate giving you the background why that was made and a continuing concern from some of the neighbors that I've spoken to. The neighborhood below what is now called the Garrett Ale House has really changed, and they're not aware of the conditions that we lived under at that time, although I don't expect that the Garrett Hill Ale House would ever allow the behavior that was concerned at that time. But I think the backstory is important.
Thank you for that. We will get back to you at hopefully not too distant future. Okay, so here, I'm sorry, who's here for the applicant? You're on mute.
Can you hear me
Oh,
now?
nope. Yes, now
Yes.
I can hear you.
Yes, so we are the applicants. I'm Angie Mitchell, this is Jean Mitchell.
Okay, Norma, would you like to swear the Mitchells in, please?
Yes. If you would both raise your right hand, please, I'll swear you in. You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
Yes, ma'am.
State your names and spell your first name, please.
My name is Angie Mitchell, spelled A-N-G-I-E, Mitchell.
Thank you.
I'm Gene Mitchell, G-E-N-E Mitchell.
Thank you.
Okay, welcome back. It's been several years. What brings you before us this evening, and how can this board perhaps be of assistance?
Okay, so there's a few of you that were on the board back in 2017. There's several that are new. I don't really want to go through a lot of time and wasting everybody's time, but just to give you kind of a little bit of a backdrop, we own the Garrett Hill Ale House. We purchased it in 2011, and we've turned it around. It was owned by many people before us, but we came in, we established a good business, and we're going on 10 years next year, which is a lot more than other owners of that on that corner have done. The package that I put together, it's very similar to the one that we submitted in 2017. It contains some photos of the building. It contains the original 2003 zoning board decision that it's labeled number 2575. And then I also include the one that was decided in 2017, which is a relaxation of a prior decision from the 2003 board decision. I also included some photos, the original site plan. So that's all in there. And to give you some background history of why we're here. So like I said, we opened in 2011, and in 2017, we decided we needed to upscale the restaurant. We did a complete interior renovation. We put windows in, we did new furniture. We went through a lot of expense to make things nice for the people coming in. Shortly after or during renovation, we were told of a restriction on this property that restricts us from opening those windows. We then filed an appeal with the board to have this re-looked at to see if there could be a relaxation of the restriction. So that's what happened in 2017. And we presented our case, and the board agreed that we could, under restricted limits until 9 o'clock, open the windows. And then 3 years, we were supposed to come back and have actually the quote was, "opportunity to review whether the relaxation has proved consistent with the interests of the community." And that's why we're here. We have had no noise ordinance issues. We've had no complaints. We've had no citations on our liquor license. We've been operating the same way we have for the last 9 years, and we're established. We're credible operators, and we just think it's time that this restriction be removed from this property. I think we've proven ourselves to the community. And there was something when preparing for this in 2017, Mr. Sean Kresh, on behalf of the Township, who was the opposing counsel, he said when we presented that there had been no noise complaints on this property, he had said, "There are no noise complaints at this property because this restriction was in place." And now 3 years later, I still have no noise complaints. I have no neighborhood complaints that have been given to either of us, which proves it's not because of the restriction, it's due to the manner in which we operate our business. And that's what we want to enforce in the community. We're very community oriented. We care about the neighborhood. We just think that it's time that circumstances have changed, and everything's changed, and we're just ready to have this restriction removed.
And has the temporary relaxation that was granted in 2017, did those limitations in that relief make running your business more difficult? Did you run your business in the same way that you otherwise would have run your business? What can you tell me about the effect that the conditions with respect to the time that you can have those windows open has had on your business?
Sure. So, I mean, in the restrictions, it said that we were allowed to keep them open until 9 p.m., which we've complied with every day. It would be nice to have them open at least until our kitchen closes at 10 o'clock. But I mean, I understand that 9 o'clock, it starts to get dark and it turns into more of a community. People are putting their children to bed. So I kind of understand the restrictions. It hasn't hurt us, but it has definitely helped our business to have windows that operate.
And is the request that you're making of the board now that the time limitation also be removed such that that the windows can be open during any time that the business is open for operation?
No, I really don't want. I want to have them closed at a reasonable time. I mean, that's community. That's what we're about. I'm not asking for that to be removed at all. If anything, maybe till 10, but 9 is acceptable as well.
Okay, and I asked that question because the request for relief is stated as the removal of the condition that's in paragraph 14D of the order, the original order. And Ian, if you could scroll down down to 14D. Yeah, okay, thanks. That doesn't have any temporal or time limitations in it. So when you say you're asking that be removed without additional restrictions from the board, it would be that you would be able to have them open at any time that the business is open for the public. But you're suggesting that that's not what you're asking for, at least in the full entirety of that.
Right. I mean, correct. I mean, if you're looking at the 14D specifically, yes, I am asking that to be removed from the regulations that are under this property. But more importantly, on the appeal from number 3000, where the restrictions were put in place to have them time closed by 9 p.m. I'm not certain how to do this, other than I'm just trying to work with the community and do what I think is reasonable for everyone. Okay.
Any other board questions for the applicant?
Are you aware of any other restaurants in that area or businesses that are required to keep their windows shut by ordinance?
No.
I think that was the same answer you gave 3 years ago.
Okay. I'm sorry. The other question that I was going to ask relates specifically to whether, in connection with this request, whether you've had any discussions with members of the immediately surrounding neighborhood about the request, because obviously it's an engaged community, and they probably would notice a zoning notice with respect to this property and this issue. But have you had any recent conversations with neighbors regarding this request?
Oh, yes, in fact. So I guess it was a month or so ago now, we had a community block party that was coordinated with the Radnor police. And we had a lot of community come out for it. And we kind of mentioned this was coming up and kind of asked for feedback. Of course, as probably most people know, we're still closed there. A lot of community has given us some heartfelt condolences to get through it and reopen eventually. But, you know, I did bring this up to a lot of the people who were there and who are customers, you know, that I'm having to go back to the board, you know, have you heard anything? And everybody said they're so happy that we have windows, especially given the circumstances now. I haven't heard any negative feedback, and everybody's been very supportive about it and just asked what they can do to help. Now, the fact that this wasn't an in-person meeting doesn't help people show up for our support, but there are a lot of people in the community that do support us and are hoping that this, you know, continues, that we're able to keep our windows open.
Okay. Any other questions from the board?
John, just real quick, it's Rich Weitzman. I just want to clarify who the applicant is, because the ownership is the limited partnership, but on the appeal it says Garrett Hill Ale House. Before we do anything, I just want to make sure that, I guess procedurally, we've got the right folks.
Yeah, I think appeal number 3000, which is part of the submission package, has the LP, which is stated here is 157, 159 Garrett Avenue LP. So the deed is 157 Garrett Avenue LP. And typically, unless the property, that would be the appropriate applicant for the relief. Is 157, 159 Garrett Avenue LP, that's the same partnership that is mentioned in the lease? I'm sorry, the deed? This is a question for the applicant.
Yes, it's the same. 157 Garrett it's Gene and Angie Mitchell, and Garrett Hill Ale House is Gene and Angie Mitchell.
Okay, and the original applicant, JMD, 157 JMD LLC, I'm assuming that was that a prior owner of the property? It doesn't look like it, but
they were the prior owner. They're no relation to us.
Okay. And again, this relief is applicable to the location as opposed to any particular person or entity. But Rich makes a very good point, which is when we issue an order, to whichever way the question goes, we just want to make sure we're identifying the right party. Rich, does that answer your question?
Yeah, I think so. I guess more specifically, I'd ask the applicant. So, Ms. Mitchell, you're one of the owners or controlling members or partners of the owner of the real estate?
Correct, yes.
Okay. Yeah, that answers.
Okay. And the real estate's not owned separately from the business, or is it? I guess with the liquor license, probably not, but.
It is.
Yeah.
So the real estate is owned in a separate entity from the business, and the business owns the liquor license.
Okay. But the property owner is the 157 Garrett.
That's
Avenue LP. Okay, great. Thank you. Okay, if that does it for board questions, we can move to Ms. Pilling if she rejoins us from mute land. Good evening again.
Yes.
So Ms. Pilling, please let us have your thoughts on this.
Well, what I wanted to primarily, first place, I've lived in my home on Garrett Avenue for more than 38 years. And although my address is 29 and they're 157, there are 18 40-foot wide properties between my house and 157, which is the best way to refer to it.
And did you receive mail notice of,
Yes.
notice by mail? Okay, that's
Yes.
fine.
Yes, and I
Perfect.
contacted Kevin, and then I talked to Gus Eucomides about participating live because this is a Zoom call, not in purpose. The reason that the agreement of 2003 came in was the neighborhood had lived through what could really be described as a nightmare when it was under the aegis of the Brick Bar. And we had tried everything we possibly could. When Dave Cannon became our commissioner, he heard not the cries, but he heard of the concern of the neighbors. At one point, there were 110 citations against the entity that was then part of the Brick Bar in a 6-month period. And although the noise and more the noise went down Williams Road, which is sort of the southern extension of Garrett Avenue, the vandalism and the noise and the disturbance came up Garrett Avenue past my house, along with many others, as it's unfortunate to say the majority of the people who went there were Villanova students. And so personally, I had people urinating in my front yard. 2 young people had sex in my driveway every night at about 2 o'clock. On the nights when they had this, they had 25-cent beers on Thursday night. They had about 100 people there. They had no food. And through Dave Cannon, our commissioner, and Greg Vitale, we were able to connect with the Liquor Control Board under the Neighborhood Nuisance Bar program. And we got the place closed down. And Mr. Cornelia was very instrumental in getting the agreement. The windows had to be closed at the time. The baffle was required outside the front doors, so the doors swung open, the noise didn't go down the hill. It did not end with that. And I just want you to know that on a Friday morning in early August of 2003, Anna Kondravi, Dee Delaney, a young woman named Carrie, and I don't remember her last name, and I came out to go to work, and all our tires had been slashed. So we had one car was too close to a building, so they couldn't hit the tires on one side of the car, but we lost collectively 18 tires that day, which was our expense. And Chief Gregory was the superintendent at the time, and he went to them and said, I can't prove you did it because there are no fingerprints, but if you ever do anything against these women again, I will drive you out of the township. And because my house was up the street, sort of isolated, I had a closed circuit camera and police watch on my house for 3 weeks. That's how serious it was. I have no objection. I think the neighborhood has changed. Angie and Jean, although I have never been there, and that's not because I don't want to go, but I'm a pretty severe celiac, so I can't drink and I can't eat anything that has had any kind of grain anywhere near it. So I just don't go. I stay at home. I really have no objection of it staying open till 9 o'clock, the windows open. I would ask that if they're going to have music, the music starts after 9 o'clock, or they close the windows, because the sound goes in a straight line, and it's going to go right down Williams Road. And we have a lot of young families. That's been the value and continues to be the value of Garrett Avenue and Williams and the area. I bought my little house for $35,000 in 1982. Houses are going for over $300,000 in a day right now. And we have some more expensive houses that have been built recently. So it's an affordable neighborhood. It's a very tight neighborhood geographically. And it's a place where young families who want to live in Radnor, and maybe just there primarily because they want to be in the Radnor School District. It was just listed as #1 public school in the state. I don't want them discouraged because of what the issues we went through. 2 of the neighbors, Carrie and Anna, moved immediately. They no longer felt safe. So that's really water over the dam. Angie and Jean are not like that, but I felt it important for you to understand why the restrictions came in. We were under siege for a number of years with the brick bar. J.B. Garrett was the one that came in next. It was the same owners and a young manager. It didn't last very long. Then it was Kebab, which was an Indian restaurant. That failed because the neighborhood didn't support that type of food, I guess. And it's good that the Garrett Hill Ale House is here. I walk a lot. I live alone. I walk a lot. And I have noticed young families on Sundays when they were open, and mostly evening, what I would call locals, not necessarily coming into Garrett Hill, but Garrett Hillians using it as a bar. And I can understand why they're closed because the bar is not that long. And if they have to be 6 feet apart, there's not room. So I just wanted to give the backstory. I think the history is important. Often things end up in the misty past and you have newer boards and they don't know what's gone before or why it happened. We were not an organized group except that we came together. So we were the concerned neighbors of Garrett Hill. It was 4 women who did it. The men they didn't like it, what was going on, but they weren't willing to stand up. And we women paid a price. It cost me $500 or $600 to buy new tires, 4 new tires for my car. And I was working 2 or 3 jobs to try and survive at that time. God bless Social Security. But I was a much younger person in 2003. I wish Andy and Jean well. I am really appreciative of the fact that they are neighborhood oriented and they are already closing the windows at 9. And I see it as a good compromise with the addendum that they don't have music before 9 o'clock when the windows are closed. And that's all.
Thank you, Ms. Pilling. That background is helpful. Are there questions for Ms. Pilling from members of the board? Okay, thank you. Kevin, I have not seen any email comments come in. Is that correct?
Correct, Mr. Chairman, not for this appeal. We do have one pending for the next appeal.
Okay, great, thanks. Okay, we'll need a motion to get the conversation started. Go ahead, George.
I'll make a motion. I make a motion that we grant the request that condition 14D be eliminated entirely.
Is there a second?
Sure, I'll second.
Okay, board discussion?
Yeah, my thought on this is it's clear, it was clear 3 years ago that 14D was a good compromise 17 years ago, back in 2003, based on the conditions. That has changed significantly, as we are told by the testimony. As I recall, when we discussed this 3 years ago, the compromise was the 9 o'clock limit, and I don't know where the 3-year period came from. I didn't agree with it then. I don't agree with it now. I have a vague idea, but
yeah, George, it's you and me now, so we can have this conversation.
Okay.
My recollection was that it was put forward by a prior chair
That's right.
as a reasonable period within which the applicant could prove to the community that the relaxation of that provision is warranted or not
Right.
warranted.
So I'm hearing that they have proven that and they have met that standard. I guess the biggest problem I have with including a 9 o'clock limit, we're in a pandemic, and to tell a restaurant they have to close their windows, to me, is beyond comprehension. I think it's just silly considering what we're going through right now. These restaurants are barely surviving, and you know, in the warmer weather, and if there are limited seating indoors, and you know that'll come back at some point, to be required to shut it tight, I think is frankly irresponsible. And I think they can use their own judgment as to when they should close their windows. And I do recall from 3 years ago, I think they're the only business that has this type of situation, and it was based on a past history that the current ownership has nothing to do with. So I just don't see any need for the condition going forward. Plus, I think it's just a bad idea.
Jamie?
I agree with George 100%, especially the nature of where we are. My only question is, and I mean this with no ill respect, if this business doesn't stay open and all these provisions are gone and a new business opens, they would be under the same rules and regulations everybody else would be on that street. And I know that sounds like Ms. Pilling just never wants to return to that college bar situation again. Is it something where we could amend the removal of a condition based on this owner and not have any time limit on it? So while it's these owners, it's not a concern? Or is that something that's not appropriate?
Yeah, my recollection from when we had the discussion 3 years ago was that it cannot be personal to the operator of the premises, but rather is a condition that relates to the use of the land. Maybe the solicitor could weigh in on that one.
I mean, you stated it correctly. You can't make your decisions based on who's in front of you. It has to be based on the land and or the use of the land.
Okay, thank you.
And I hear the concern that's behind that, because time, just the circumstances changed from it going from a bad operator, well, an inconsiderate operator to a more considerate operator. There's nothing necessarily that prevents that from going the other way to some extent or another. I mean, certainly I think that the evidence would suggest that this current operator is not anything necessarily to worry about.
Right.
But what comes next is always of concern. Rich, thoughts?
No, I think what George stated was right. I appreciate Jamie's question and the concern of granting the relief in that broad sense. But based on what I'm hearing, I'm inclined to vote in favor of removing the restriction.
Okay. Why don't we call the vote at this point on the motion to grant the relief requested, which is the removal of the condition number of paragraph 14D from the I'm grabbing it here, from the limitations imposed under Appeal 2575. Jamie, are you for or against granting the relief?
I'm for granting the relief.
Rich?
I'm in favor.
George?
In favor.
and I'm also in favor of granting the relief. I do it knowing that we have an engaged neighborhood, and folks will be interested in how things go. But that's a 4-0 decision granting the relief that's requested. Good luck in the future whenever you can reopen. We hope it's soon, but we hope for a lot these days, and we seem to come up with not a whole lot. But good luck, and we hope that you can get back to business soon.
Thank you very much.
Yes, thank you. Thank you all very much.
Okay, great.
May I ask, Sarah, how do you spell your first name? Sarah, S-A-R? Unmute. You have to unmute.
Sarah, Ms. Pilling, you're on mute.
There we go.
Oh, yeah, you had it. S-A-R-A. Just nod now.
Thank you.
S-A-R-A.
Yes.
Great.
Thank you.
Thank you. Thank you. And Ms. Pilling, thank you for participating. It was helpful background, and it's good for us to be mindful of how we came to be here.
Well, and thank you for allowing me to participate.
Certainly. Thanks. Okay, moving on. Appeal number 3081, the applicant Taylor and Allison Rook, property located at 422 North Bellevue Avenue and zoned R4 residential. I don't know why I said Z. The applicant seeks a variance from section 280-109A, which limits the height of a fence in the front yard setback in the R4 zoning district to 4 feet. The applicant seeks to install a fence 6 feet high along its Eagle Road property line. In the alternative, applicant requests any other relief in accordance with the plans and exhibits submitted. Mr. Cornelia?
Thank you, John. This is, you've seen these type of applications before. It is for a fence that would be 6 feet high in the R4 zoning district. Interestingly, 6 foot high fences in the front yard setback are permitted in R1, R2, and R3, but for whatever reason, they're not permitted in R4 and R5, which are actually the areas that probably need a higher fence because they're the areas that border on busy roads, but I know that's not an issue for this board to take up. This is at the intersection of Eagle Road, right very close to where the train tracks are, and North Bellevue Avenue. The owners are here, Allison and Taylor Rook, and if you want to swear them in, please, Norma.
Yes. If you'll both raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes. Yes.
And state your names one at a time and spell your first name for me.
Okay. Allison Rook. It's A-L-L-I-S-O-N.
Taylor Rook. T-A-Y-L-O-R.
Thank you.
Thank you.
Allison and Taylor, you purchased. Hi, Allison. You're all grown up. The last time I saw you, you were maybe 13. You purchased the property in 2018.
Yes.
It's located, as we mentioned, in the R4 district that doesn't permit fences higher than 4 feet in the front yard setback, correct?
That's right.
Who do you live there with?
Taylor and I live here with our 3 kids, Asher, age 5, Remy, age 2, and our daughter Sylvie is 9 months old. A3 is the aerial.
Call that up. There you go. Thank you. And Allison or Taylor, whoever's testifying here, I think, Taylor, you have this part of it. That property is located at the corner of Eagle Road and North Bellevue Avenue?
It is, yes.
And what kind of road is Eagle Road?
From a traffic perspective, it's pretty busy. So there's a lot of traffic as well as foot traffic as well, because we have a sidewalk that goes along Eagle Road.
And are you close to you're close to North Wayne Avenue in the middle of Wayne?
We are. Yep.
And the train station's actually both Stratford
And Wayne. Yep.
You notice it's a corner lot. And where is your front door? Is it on Bellevue or on Eagle?
It is on Bellevue.
And the rear of your house is oriented opposite your front?
That's correct. Yes.
And so Eagle, you kind of treat that as a side yard anyway?
Absolutely. Yes.
The area on Bellevue, that will still be a 4-foot high fence in that location?
It will be. Yes.
So you're only asking for relief for the fence on Eagle Road?
That's correct.
A4, Ian, is the site plan. And again, this site plan just confirms where the front of the house and your driveway is also on Bellevue, correct?
Yes. Yes.
And it shows, right there at the bottom is Bellevue and on the right-hand side is Eagle Road, correct?
Yep. Yes.
If I'm going to show you A5, if I can show you A5. Is this photo taken from Eagle Road?
It is. Yes.
And is that the current fence?
That is the current fence.
And that fence along Bellevue, that will remain a 4-foot high fence, as we mentioned, correct?
Correct. Yes.
And you're looking to replace the fence that's actually on Eagle Road that we're looking at straight on.
Yes.
And that's the side of your house we're also looking at straight on.
That's the side of our house. Correct.
If we can go to A6, Ian, please. There you go. Now, this is a view, again, taken from Eagle Road up the side of the fence.
Yes.
Now, you see in the background there a 6-foot high fence.
Yes.
Is that the type of fence you intend on installing along Eagle Road?
The exact same.
I notice you have a swing set there.
Yes, we do.
Okay. And A7, if we can look at A7, Ian. And this is a longer view of the fence in the area, your side yard there. Would that be accurate?
That is accurate.
Right now, Allison, a couple questions for you. Obviously, we're installing a privacy fence here along Eagle Road. What's the reason for that?
So we kind of have three main reasons for why we want a privacy fence, but there's really, the last I'll get to is really the most important. So when we moved in, one of the things we loved the most about the house and why we bought it was for the yard and the walkability of Wayne, which we feel so lucky to be a part of. But what also came with that, I didn't really think about it, was how many people would walk next to our house. And so I think also, like we mentioned before, with being situated basically between the two train stations, which is awesome. It's also a wonderful thing for us, but we have a lot of foot traffic, and a good amount of it is people walking their dogs, which is part of the reason why we want the fence, because our dogs bark a lot at our neighbors, which we don't like and we feel bad about, and are often trying to get them in the house as a result. And then of course, also those people walking by just see into our property and what we're doing. And, we try to be outside a lot, especially now with everything with COVID. And it's, it's a little bit frustrating for everyone to see everything that we're doing. But the main reason, which is really the reason why we're here, and something that Taylor and I have struggled with a lot, just, how are we going to handle it basically, is having the 4-foot fence and having people who are so close to our kids when they're playing outside. And I think the concern for us is just literally this fear that someone could just reach over our fence and grab our kids. And being that it is we consider it a side yard, but the kids can run from the front to the back. And if we're sitting on our front porch and our son Asher our 5-year-old asks to go to the back, or they run to the swing set, we are genuinely concerned not to have eyes on them at all times, because of the fact that we just don't know. And like we said, because of that foot traffic, we've talked a lot about over the 2 years that we've been here is that we don't also know how much of the foot traffic is actually local, and is it people that are coming off the train and trying to get to work. People work in the neighborhoods. We've seen a lot of people who, I don't know if they're childcare or whatnot, but it's extremely concerning to us. And I just, being that our oldest is 5 and we still have a 3-year-old and a 9-month-old, and just the amount of time that we spend outside and having that lingering fear of something happening to the kids has brought us to the point where we wanted to bring this to the board, and just really in hopes that we could feel honestly a little bit safer when we're outside in the property.
Thanks, Allison. That's all I have at this time. If the board has any questions.
Thanks. Are there questions from board members?
Sure, I have one question. It's Rich White.
Can we take the picture down so I can see everyone's tile? Thank you.
Sure, it's Rich Weitzman. Whether somebody could address the impact on any sight lines, coming off of Bellevue, making a turn onto Eagle, or even if I'm traveling, I guess it's eastbound on Eagle, how would the 6-foot fence impact any of those sight lines?
Yeah, I can address that. So I guess the previous owner, or when the original fence was put up, the corner of Bellevue and Eagle, the fence was built back, so it's not directly on the corner. It doesn't create a 90-degree angle. So there is a sight line that when you're on Bellevue, looking either up, I guess up on Eagle or down, I guess it would be up because that's where the property is.
I think it's west and east, but
I think it is too. Yeah, right. So when you're looking up towards the up the hill and where the train goes under, there is a cutout, as well as my wife Allison was mentioning, there's a sidewalk which creates additional space that you can see from the car.
Okay. So the fence wouldn't go, right. So the fence doesn't go all the way up to the edge of the yard. It's to the sidewalk.
No, it's actually
inside the sidewalk, really.
It's actually inside the sidewalk.
Yeah.
Yes.
It's actually something that we considered when even putting this appeal in. Would this be a problem for not only other people, but for ourselves, for our sight line? And we were like, we didn't think so at all.
It actually shows on A5 how it goes at that intersection.
And the existing picket fence, that's 4 feet?
It is, correct.
Okay, thank you.
Thank you.
Mr. Chairman, this is Kevin, if I could add, all corner properties are reviewed specifically by our traffic safety division of our police department for specifically that issue. So they will go out, measure sight distance, measure site safety requirements, and the fence would be installed according to those guidelines established by our police department for those specific concerns.
And that will be specifically listed on the application for the permit, right?
Every permit that comes in that is a corner property automatically goes through our police department and our traffic safety division.
Jamie or George, any questions?
I have no questions.
One quick question. I just want to make sure I recall the testimony correctly. The fence is going to be solid as opposed to the picket.
Correct.
So there's the fence at the rear of your property, which is the side/front of your neighboring property there, and it's gonna look like that as opposed to having any sort of ability to see some portion through.
Yes.
Okay. Okay. I don't have any other questions. We do have a public comment email, so I'm on a couple screens here, so I'm going to turn away from the camera now and read an email that was received in the public comment mailbox on this application. This is an email from Joan Patrick that's dated Thursday, November the 19th at 7:01 p.m. And it's regarding appeal number 3081. The email reads as follows. I would like to comment on Appeal 3081. The request states applicant would like to install a fence 6 feet high along its Eagle Road property line. I meaning the author, I assume that would be in the same location as the existing fence. I am concerned that it would further limit visibility of traffic coming down the Eagle Road hill toward the North Bellevue intersection. That intersection is already difficult. Traffic comes down the hill consistently over the speed limit, and because of the existing fence and the trees between the fence and the road, it is difficult to see traffic coming. Adding 2 more feet to the fence height will make it worse. If the fence could be placed a few feet into the yard, I think that might help. I assume the township has engineers and traffic experts who can weigh in on the safety at this intersection. Thank you, Joan Patrick, 417 North Bellevue Avenue, Wayne, PA. Kevin, I don't see any other comments other than that email. Is that correct?
That is correct.
Okay, great. So at this point, I'm sorry, Nick, if there's nothing else, do you want to enter the exhibits into the
I'd
record?
like to enter the exhibits, and I believe that that concern has been addressed. That the police.
Okay.
Check that.
We'll enter those exhibits into the record. In the interest of time, I will make a motion to grant the relief that is requested to permit a variance to erect a 6-foot high fence in the front yard of the property. Well, we don't have plans, I'm sorry. A 6-foot high fence in the front yard of the property at 14 Bellevue. Is there a second?
I'll second.
Everybody second, Norma. Everybody.
I'm sorry. Okay.
You can give
We'll
it to
give it to Jamie. We'll give it to Jamie. We'll
I'll
give it to
pick
Jamie.
somebody. Okay.
Okay, board discussion.
Yeah, I'll be brief. You know, I thought the applicant's answer was fine in terms of any negative impact on the community, and most certainly the additional. I was not aware, what Kevin pointed out to us, that it would require some sort of study by the Radnor Police Department. So as a result, I'm comfortable with the request, and I'll be in favor of it.
Yeah, being the owner of a corner property that had to put a fence up, I'm familiar with the process that the township goes through. Now, our fence was different because it's just a post and rail, so visibility is not as much of an issue. And in reading the materials, my primary concern, frankly, was the effect on visibility up Eagle. Just because, as the commenter points out, it's a fairly busy road, and not everyone complies with the speed limits that are posted. So it will have an effect on people's ability to see up that street. I mean, there's just no getting around that. The question is whether it impacts it such that the public safety folks are going to have an issue with it, and they will do what they're going to do and make their determination of the appropriateness of the fence when the permit application is submitted. So I'm inclined, on balance, I'm inclined to support the motion. George, do you have any thoughts?
Yeah, I mean, it is a very busy road, and there's plenty of 6-foot fences along that road.
Yeah, and you know, if you put up 6 feet of hedge,
yeah, that too.
we wouldn't be here. But okay, if there's no other discussion, I'll call the vote. Jamie, are you for or against the motion to approve?
For,
Receive? Yeah, I know.
yeah. Yes, I approve.
Rich?
Yes, I'm in favor.
George?
In favor.
And I'm also in favor. Good luck with your project. That's 4-0. And I believe that's everything for this evening's agenda. Enjoy the Cardinals and Seahawks.
Thank you.
And
Thank you.
we will see everyone on December 17th for the last hearing of the year.
Correct,
Thank you.
Mr. Chairman. There is
Thank you.
one agenda item for that meeting. So regardless of the outcome tonight, we did have one agenda item. So
Okay. All right, great. All right. Thanks, everybody. Have a great evening. Thanks for
Thanks, John.
participating.
thank you.
Mr. and Mrs.
Thanks,
Rook, good luck
Kevin.
with your project. Thank you.
Thank you.